concerns, but what can he be legitimate sued for?
Well, legitimate is not giving notice of a transfer of a loan. Legitimate is taking an active role in helping the debtor prepare their income and expense numbers. Legitimate is not applying the payments in a proper way.
Acting in concert with an appraiser to inflate
Right.
appraisals to defraud the secondary market.
It does. We do see situations where lenders disappear, checks are returned, nobody knows who owns the loan. You certainly wouldn't want to see somebody lose a home because they tried to find out where the payment goes. Application of the payment, the dumping of late fees when there shouldn't be. I mean, there are abuses out there. I mean, and there's been loans that, hey, I think there are grounds to say this loan should have never been made, and you took advantage of the borrower in a certain situation. Many home loans and maybe refinances, case by case.
But Judge, what's the remedy for the homeowner, right? It's not a free home unless there's been some fraudulent act perpetrated upon that borrower, right?
No, I mean, where I've seen abuses, the argument, the debtor and the homeowners come in and they say, we like to void the mortgage. And the money was loaned. Is a legitimate debt. What makes the most sense to do, what Congress refuses to do, is to allow cram down in more situations where the value of the debt is crammed down to the value of the amount of the debt is reduced to the amount of the property. That makes a performing loan possible. It helps the neighbors. It helps the community, and it would make sense. And that would be the relief to the debtor homeowner. They have to pay something what's reasonable.
And by the way, that was the state of the law up until.
And we can still do it in 11.
Yes.
In 11s with non-residential.
Yeah, but you're not going to file an 11 for an individual.
Right. Well, you still can't do it on residential. Right?
Yes.
How many of these loan officers get in trouble for inflating the loan amount, saying that the homeowner can afford this and that and the other thing? I mean, of all these bankruptcies, it seems like they always come after the appraiser. How come they never go after the loan officer for not due diligence in their part?
Well, I think Richard brought up a good point. Who has E&O coverage? The loan officers, a lot, mortgage brokers are out there.
But again, I think it goes to the way the judge was responding to the question in the Kentucky case. You have to find a level of intent or active participation by the bank officer in order to pin them liable. And if you were, you'd end up, the relief would be against their employer, the bank. So I think the instances that I've seen where you can really prove that are extremely difficult.
Let's be honest, these loans, unlike 15 years ago, and you're familiar with it, it's not the bank holding the mortgage. It's the mortgage broker who had only incentive to get the loan approved, work with the bank, and then in days it's shipped into, becomes part of a portfolio that's sold and resold and resold. That original loan officer is no longer involved by the holder of the loan. So when the homeowner is contesting the foreclosure 8 years later, none of the people are there.
Mortgage company's gone. Principal's filed back.
Right. How many mortgage companies have actually filed Chapter 11 in Delaware? I mean, countless.
Many.
Well, why don't they put stricter? Rules on these loan officers and mortgage officers so that they can't do this stuff and then disappear 8 years later when these people are in trouble because they said, oh no, you can afford $200,000 when they could really only afford $150,000, and now they're all upside down. They're losing their jobs. They're losing their houses.
Well, the same. I agree. Regulation of the rating agencies that rated. I mean, they rated these loans great loans. They shouldn't have been. Regulation of the mortgage broker industry. It would be nice if we actually went back and the lenders actually held the loans, and they'd have an incentive in making sure it got paid. Otherwise, there's no incentive. There's a question way back.
Yeah. Ken, wait for Mike.
Yeah, hold 1 second. I'll make a quick statement. I'll come back and give you the mic. This would be for the appraiser. I want to ask a question. If we as appraisers are looking at situations that you have to deal with by law, this is where we should get with NAIFA's legislative committee and make some kind of march on Washington, make some changes, right?
Absolutely. Because it's easy for you all to be the scapegoats.
Yeah.
I believe there was a bill that didn't pass, I think you touched on it before, where judges would have the right to bring the value of the property down to what he felt was fair and obliterate that remainder of the mortgage. In other words, a $500,000 mortgage, and the judge says it's $350,000. I think cram-downs only apply to mortgages subsequent to a first mortgage. Am I wrong?
Now, here's the situation. Sure.
Does the judge have the right to reduce the interest rate and change the terms of an existing mortgage?
Short answer, yes, in situations. Modification of home loans. We're talking about a home loan now. In a commercial loan on a building, as part of a Chapter 11, the parties and the court can change the maturity, the interest rate. It could be restructured in every which way.
So that is critical. Just so you take that away from this seminar. In a commercial setting, that is one of the great remedies of Chapter 11. That in a commercial setting, you can do that. We could do that for this hotel. Okay.
But
the judge.
Ultimately, the court. And the parties may fight over what's the proper interest rate, what's the proper value. What we've been referencing in cram down, with respect to residential properties.
But just before you get to the residential, because I know you're going to do that, but it sounds like there's some interest in the commercial, and that's where we make our money. So the bottom line is, I'm confirming cases now at 3.5%, 20-year amortization, 5 to 10-year balloon. That's significantly better than people who in the go-go days closed loans that were at 7 and 8. It's huge dollars.
Actually, you have the till rate. You have the Supreme Court in till.
That's right. And smart lenders are starting to agree to those plans.
Outside,
It is not like it was maybe 15 or 20 years ago, where a single asset real estate entity would file and propose a plan, and there would just be no. In response by the secured lender. I'd rather take my property to foreclosure and get less. Now lenders are saying, I see the economic reality here. I see that my hotel, my collateral, is not worth $15 million over my $10 million debt. I see now it's worth $7. And I am willing to face that reality, and I'll negotiate with my borrower so long as my borrower isn't a crook. If my borrower hasn't stolen money or otherwise done something wrong, if he's just or the entity is a victim of the market, the lenders are coming to you and saying, okay, I'll rewrite this loan down to today's commercial terms.
Dan and I just confirmed the case in Newark where he represented a bank, I represented the borrower. We owed him $8 million secured. He agreed in the 11 to cut his mortgage to $4 million. As part of that, he agreed to work with us on the interest rate. We agreed, I don't remember the numbers, but assume we started at 3.5. We agreed in year 2 to go to 4, 4.5. Keep in mind, as you all know, a lot of these structures are prime plus 3, prime plus 2. I'm sorry.
Which was wonderful. It was a great case until Richard objected to my fees.
Right. You still got it.